All right, well, good afternoon to this session of ezCPD. My name is ERIN Heyman, one of the facilitators, and today with me we have Michael Reid, who is Senior Law Clerk at Will Davidson. Michael actually has a long and illustrious career at several prominent litigation firms and is now with Will Davidson. And with Will, Davidson has been part of several class action suits against long-term care facilities, which is what brings us here today to talk about. I know the last 2 years have been precarious, to say the least, and that certainly shone a magnifying glass on our long-term care facilities. So we are happy to have Michael and his expertise here today. And thank you again for joining us, Michael.
Thank you. Good afternoon. First of all, I want to thank the organizers of the seminar and for inviting me here today to present this very important topic. I also want to thank everyone who has joined in. COVID-19 has shown us something that has been known for a very long time, and that is we have failed our seniors. COVID-19 put a spotlight, no, a floodlight on this. The proposed class actions we have against long-term care homes all started by being contacted by family members who lost a family member in a home due to COVID-19. We were contacted by families from various homes. At times, we used social media to put out a message that we were investigating a particular home, and this helped facilitate the contact. We determined the best way to handle these matters was to bring class actions to protect the rights of residents and their families. There were common issues, and we thought the families needed to get answers, and someone had to be held accountable for the gross negligence of these long-term care homes. Finally, the hope of these class actions, in any class action, is to achieve behavioral modification. I'm now going to give you a background on how bad the long-term care homes were in Ontario during COVID-19. The data that I am going to be referring to is courtesy of the Ontario Health Coalition, who we have worked with at times during the pandemic. We as a firm originally had 14 proposed class actions against separate long-term care homes and retirement homes. There have been some additional chain claims added, and we are still investigating other long-term care homes. We are now part of a consortium group of 8 law firms, and this consortium has 8 consolidated actions, which involve approximately 400 homes. To put that into perspective, Ontario has a total of 627 long-term care homes. So the data. From March 2020 to June 2020, which of course was the first wave, there was over 5,400 resident infections and over 1,700 deaths of the elderly residents. The next few slides I have provided the death counts for various homes in wave 1, and we were involved in actions against all of these homes. In addition, I will be providing some details about Extendicare and its management of homes, including Orchard Villa in Pickering. Orchard Villa was the worst home in the first wave and had 78 deaths. The families have told us that prior to 2015, when Orchard Villa was owned by a family, everything was great. All went downhill after the home was purchased by Southbridge, who hired Extendicare to manage the home. Extendicare has had its issues in the United States and were charged by the US Department of Justice. And it was determined that they were billing Medicare for services that were so deficient that they were pretty much worthless. Extendicare ended up paying $38 million to settle a case. It was the largest failure of care settlement in the Justice Department's history. Question. With all the trouble they had in the United States, what did Extendicare do? Well, they sold their American portfolio and made a major move into Ontario. Their plan was to grow and expand their business here. The owners of Orchard Villa actually described Extendicare as a leader in quality services. What a disconnect. One thing we found very helpful when investigating long-term care homes was the ministry site that listed investigations completed and the outcome of those investigations. We incorporated the investigation within these statements of claim as background information. As you can see, Orchard Villa between 2017 and 2018 had a number of warnings, voluntary plans of correction, and compliance orders. Compliance orders are issues when the home is non-compliant with the Long-Term Care Homes Act. However, the unfortunate thing is that we discovered that at times, these warnings and plans of correction and even compliance orders were still not followed. We researched the time period 2017 to 2019, which of course is pre-COVID-19, to show how bad the home was before the pandemic, and then formulate an argument. How did they think they could handle or control a pandemic when they were so bad before? Some more homes to illustrate the COVID-19 tragedy that was allowed into these homes. The village of ERIN Meadows, 21 deaths. This home, I have heard a number of stories from families, and some of them are very disturbing. I heard, as I said, very disturbing, and this included the most appalling of all, being a sexual assault of a resident by another resident. ERIN Mills Lodge had 19 deaths. Actually, it says there are 21 deaths, which is even worse. But we have to remember, they only had 86 beds in this home. So that ratio obviously is not great. The village of Humber Heights had 38 deaths. Grace Manor at Holland Christian Homes in the first wave had 12 deaths. This is one of the homes in which the military was in helping and is therefore mentioned in the military report, which I will talk about in a moment. INA Grafton Gage Home had 31 deaths. We originally had issued an individual claim against this home, but it is now part of a consolidated claim with other homes related to the responsive group, who manages many homes, including INA Grafton Gage Home. Seven Oaks is a municipally ran home, and it had 41 deaths in the first wave. As I said, it's owned by the City of Toronto, so they are a defendant as well. But we did discover, for the most part, that the municipally owned homes fared better than the privately owned homes. Ballycliffe Chartwell, 31 deaths. This action, which we did also issue an individual action initially, is part of a Chartwell chain claim, which is being handled by the consortium group. The military report. The military was sent into 5 homes to help during the first wave, and they identified in the report the medical, professional, and technical issues present. They concluded that there was not enough staff, and they failed to follow the Infection Prevention and Control Protocol called IPAC. The report was helpful with background and with developing some common issues for the class members in the long-term care homes. In addition, with the comments about a lack of staff, we were able to formulate a theory and position that a lack of staff pre-pandemic led to a staffing disaster during the pandemic, and this impacted the severity of the outbreaks and the significant lack of care received by residents. Premier Ford, press conference, May 2020, when I guess this was after he reviewed the military report, but he seemed to put his foot in his mouth during this press conference on May 26, 2020. He was talking about the military report and how appalling and disgusting it was, how there would be an investigation. Premier Ford also said there would be accountability and justice for the residents and their families. These things have not happened to date, and instead, the government made it more difficult for families to get justice with the passing of Bill 218, which I will talk about in a moment. The second wave data. The second wave data from September 20th to February 2021. Total deaths of residents to February 2021, 2,150, sorry, not 2,000. Yeah, 2,155, and over 15,000 resident infections recorded since March 2020. Tendicare Living Center. This was the worst home in the second wave at 82 deaths. Interesting, it is also managed by Extendicare. This home is included in an Extendicare chain claim we are working on with another law firm. Sunnycrest Nursing Home, 34 deaths, and Lakeridge Health had to go into this home and take over operations as the home could not handle the outbreak. The last I heard about this home is that it was being closed down in April 2022 when the temporary license of Lakeridge Health expired. The conditions in this home, according to families, was appalling, so it seems the closure might be for the best. Southbridge Roseview was impacted by the second wave and 23 residents passed away. As a claim against this home alone would have been issued after October 1st, 2020, when the Class Proceeding Act changed, and with the unknown with those changes, we decided to amend our original claim against Orchard Villa, also owned by Southbridge, to add this home and all other Southbridge owned homes to that claim. We have not had any pushback to date with this tactic. The Village of St. Clair had 63 deaths. Again, we amended our ERIN Mills Lodge claim, which is also owned by Shigo Villages, to add this home and all homes owned by Shigo. Faith Manor at Holland Christian Homes had 28 deaths in the second wave, but this is included in our original claim against Holland Christian Homes from the first wave. Grace Villa Nursing Home, I believe, is the worst impacted home in Hamilton, and we are looking into bringing an action to protect the families and residents. The hope being to obtain the Justice Premier Ford mentioned in May 2020. Here is the data from March 2020 at the start of the pandemic to May 9th, 2022, as I said, courtesy of the Ontario Health Coalition. The data says total infections in residents, 29,981. Total infection staff, 12,824. Total deaths residents, 4,502. And total death for staff, 10. This slide outlines the highlights of the changes to the Class Proceedings Act, including more stringent certification tests and changes in an attempt to speed up the process while putting additional obligations on class counsel. The Class Proceedings Act changed effective October 1st, 2020, and it is anticipated that it will make it more difficult for class actions to be certified. But until the court actually deals with this, which it has not done to date, we will not know for sure. At least the government did not make the changes to the Class Proceedings Act retroactive like it did with Bill 218. Excuse me. Bill 218 was passed on November 20th, 2020, and it offered liability protection for businesses, including long-term care homes, from COVID-19 related to negligence, if the business made an honest effort to follow public health guidelines and laws relating to COVID-19 exposure. This was made retroactive to March 17th, 2020. This slide outlines the scope of liability, and I think the highlight is that if there was gross negligence, then liability would be attracted. The issue with this is our courts have not really dealt with, for the most part, a definition of gross negligence. We had included in all of our initial claims a claim for gross negligence, so we were not too concerned about Bill 218 coming into force. However, we did decide it was right to try and help protect families and their rights. So we joined the Ontario Health Coalition in the fight against the government, passing Bill 218. We engaged our families to write submissions against Bill 218, and we added these comments to our written submissions to the Standing Committee on Justice Policy. I recall we had about 50 separate submissions from our families. We also started an email campaign having our class members email the MPPs with their thoughts on Bill 218. Mr. Will, excuse me, and I presented to the Standing Committee on Justice Policy with two of our representative plaintiffs on November 4th, 2020. Roman Babar was the chair of the committee at the time before he was removed from the PC government. We asked, simply enough, that long-term care homes should be carved out of the legislation and not treated the same as mom and pop shops. Unfortunately, the bill was passed even after we tried to facilitate a conflict of interest complaint about the Attorney General, and after writing to the Lieutenant Governor of Ontario requesting to hold off on providing royal assent until any conflicts of interest were investigated. The bill received royal assent, resulting in the government giving the long-term care homes a gift of protection from liability. In fact, it received royal assent within a few days of the vote following third reading, which is not the norm. Big question: how did Bill 218 come about and eventually get passed? Did it have anything to do with the PC government and its relationship with the long-term care lobby? Did it have anything to deal with the Attorney General's former Chief of Staff who left his office in January 2020 and became a registered lobbyist for Riviera and Sienna in May 2020, which is contrary to the 12-month set by the Office of the Integrity Commissioner of Ontario? This chart completed in October 2020, therefore it is out of date, but I think you can see that there is a connection between some of the PC government, their staff, and the long-term care lobby. In particular, some of the entries indicate that they're current lobbyists, but some of them should read former lobbyists. One example, of course, is Melissa Landsman, who is now the Conservative MP for Thornhill. It is important when dealing with a class action to use the media to get your messages out. We issued a press release on most of our long-term care class actions and delivered the press release to our media contacts, which is about 700. Mr. Will was quoted by the Toronto Sun at one point about 218 and stated some things. My favorite was, "This is a gift to the insurance industry and the long-term care lobby. It is an early Christmas present." I just want to go back for a second and talk about the individual who was a lobbyist that lobbied against, I shouldn't say against, to the Attorney General. This person was a lobbyist for approximately 1 month, from May 2020 until June 2020. And then he removed his registration 1 day before the media first mentioned in June 2020 about liability protection legislation. The CBC reported this on June 17th, and it's simply entitled, "Ontario Considers Good Faith Immunity from COVID-19 Lawsuits." So as I said, yeah, use your media. Some of Mr. Will's comments, and this was November 9th, prior to the bill being passed, but we had at that point some indication because we had already presented to the the Committee on Justice Policy. One quote, "It's giving them a weapon to use against these poor elderly residents who have lost their lives." The bill, it was at lightning speed, he said. "It's quite disgusting what the government is doing." To date, there has been no accountability. No one has been fined. Bill 218 shields wrongdoers, and the Ontario government has awarded the bad actors, including extended care, with giving them new licenses for new beds. Premier Ford said in May 2020, when he was talking about the military report, that there will be justice for residents and families. Instead, We have, because of the government, more restrictions on claims, retroactive, possible removal of compensation for families and loved ones. Important things to remember: a class action can take a lot of different turns, and you might find yourself in side fights along the way, like we did with Bill 218. You have to remember to investigate and document everything, because you never know when one piece of information, when added to other pieces of information, will turn out to be something really big and important. We listened to the stories of over 200, maybe 300 families to get a clear picture of the state of the long-term care homes and their pandemic-related failures. We were contacted by whistleblowers, and their information was helpful to fill in any gaps. The discussions with families helped us formulate the common issues for the class action. To be organized, you must be organized. We utilized a questionnaire to be organized, and we sent it out to all potential class members that contacted us. And we used this information, and this questionnaire provided us with all the information we need. To conclude, the goals of long-term care class actions, besides compensation, is to protect the rights of the grieving families, get answers, to help families get closure, accountability, facilitate change through increasing awareness of the problems, and obtain behavioral modification by educating the public of the issues. The most important goal is to give a voice to the residents that lost their lives due to the tragedy of COVID-19 out of no fault of theirs, being they should have been in the safest place and not the most dangerous. I mentioned Roman Babar earlier, as he was the chair of the Standing Committee on Justice Policy when I presented on November 4th, 2020. I mentioned him because on May 1st, 2022, we were hosting the 6 conservative leadership candidates in Burlington, and Roman is one of those candidates. I had the opportunity to ask him what he thought of Bill 218 now, and he said it is terrible, and he said to be retroactive was appalling. He concluded by saying at that time he got into a lot of arguments with his colleagues about it at that time. Thank you for listening. If you have any questions, please feel free to email me at mreid@willdavidson.ca. Thank you.
And thank you very much for joining us today, Michael. We really appreciate it. It's a topic that we really should be discussing more and should be on the minds of everybody. It really is unfortunate the government legal roadblocks that were put in place.
Tremendous.
Right as you were trying to do this. So I'm sure we all support you and commend you and Will Davidson trying to get justice and relief for some of these families who've had to deal with this. So thank you for joining us, and hopefully we'll have you back again soon.
All right, bye-bye.